Hello, and welcome to Law Talk. My name is John Celebrezze, and I'm the co-founder of the Celebrezze-Zangi Community Legal Education Project, as we call it, CZ-CLEP for short. Our organization provides continuing education about the judiciary and legislature to attorneys, judges, government officials, and the general public. As a career educator, I recognize early on how important legal matters are and how they impact our lives. I am the nephew of the late Anthony J. Celebrezze, who was the popular five-term mayor of Cleveland and a member of President Kennedy's cabinets. As a tribute to his lifetime commitment to the legal process, we dedicate this show.
John's special guest today is attorney David Sheldon, who is a Medina injury lawyer with a 24-year focused practice on personal injury and criminal law. David grew up in Medina and is well known in that community. His father also practiced personal injury from the 60s through the 80s. He began his criminal work when he served as an assistant prosecuting attorney for the Cuyahoga and Medina County Prosecutor's Offices from 1988 through 2000. He has argued cases before the U.S. Court of Appeals, for the 6th District Court, the Ohio Supreme Court, and several appellate courts. Let's join John and Mr. David Sheldon.
David, welcome to Law Talk.
Thank you, John. Glad to be here.
David, we're going to talk about a topic today that I think our viewers will be pretty interested in, personal injury. And though it's not a pleasant thing to happen to people, we know from a lot of television ads that lawyers do involve themselves in this aspect of our practice. And I think from what I gather from talking to people in my practice, there's a lot of questions. And I deliberately invited you because I got to thinking about all the lawyers I know, and I guess we've known each other professionally now for about 10 years. Time flies when we're having fun, I guess. And you're quite the trial lawyer, aren't you?
I've had my fair share.
Well, don't be over modest because, I mean, in the profession myself, I don't try that many cases, and I realize how difficult it really is. But for the benefit of our viewers here, when David's going to tell us a few things about what happens in a personal injury trial and a personal injury case, but you have actually worked on both sides of the aisle, haven't you?
I have.
So you were a prosecutor in the Cleveland area, in Cuyahoga County?
Cuyahoga County, and then was there 7 years, came out here in '96 and worked for Dean Holman, the Medina County prosecutor, who's still the county prosecutor, worked for him for 4.5. Then went out on my own. Well, went to a small boutique personal injury firm then in 2000.
So you've had the experience of being on both sides, the prosecutor and the defense attorney. But when we get into a personal injury case, when and if you try those, you are what I guess we would say plaintiff's lawyer, correct?
Yes, I do. Predominantly plaintiff's cases. In fact, I can't think of a defense case where I've been involved.
So for the benefit of our viewers, when you're the plaintiff, you're the person doing the suing.
Correct.
Okay.
On behalf of the client.
And the defendant, that's the same name we use in criminal law as well, he's the person being sued.
Correct.
Okay. But same courtroom, sometimes the same judge.
Correct.
A little different jury though, huh?
Yeah, juries in civil cases.
They're smaller, aren't they?
There are 8 people. You only need 3/4, six out of the 8 to return a verdict. So
as opposed when you try a criminal case, which I know you've tried plenty of, you need everybody
unanimous, right?
Unanimous vote. So it's going to be guilty or not, right?
Or not guilty,
I
right?
see. But you say in a personal injury case, you only need a percentage of that jury.
Right.
Okay. All right. It's kind of interesting that you wear those hats, though. I mean, you're still using your same trial skills.
Right.
Okay. Well, okay. Let's start at the beginning. We're going to hear it right from Mr. Sheldon. What is a personal injury case?
John, a personal injury case is a case brought on behalf of a client who has been injured as a result of the actions of another, and they could be actions that are considered negligent, a failure of a duty of care which resulted in injury, or could be intentional. Someone could assault and battery and hit somebody intentionally and cause injury.
I see.
Someone can be injured by a defective product, product liability case. The product's unsafe and causes injury to the plaintiff.
Okay.
Myriad of ways personal injury can occur. Slip and fall. People fall in grocery stores because something spilled and the grocery store didn't clean it up in time and they were on notice of it. And plaintiff trips and falls in a liquid they couldn't, or he or she couldn't see, and sustains a serious injury. So there's a lot of ways personal injury cases come about.
Where do you think the majority of them come out of, the bulk of them?
The bulk of personal injury cases come from automobile collisions.
Car crashes?
Yeah.
Yeah, that's what I kind of thought, based upon the firm I work for does some, I don't think we do quite as much you, but it seems like that's the majority of people come in and somehow or another they had a mishap with a car.
Sure.
I guess maybe that's a good place to start. I mean, it's all of those are excellent examples, but what is the best way for a person involved in a car wreck, David, to make the decision to hire a lawyer? I mean, I could see, well, if there's blood or you're hurting, a lot of times you have to take the ambulance ride.
Sure.
If you're going to see a doctor. I don't think there's much question about that. But later on, a person has to make the decision, do I want to hire a lawyer?
Right.
What would be some of the criteria that one would think about before you, we can't talk about what kind of lawyer you want to hire, but just the fact to make the initial decision, yeah, I need a lawyer. What would you suggest?
Well, some people don't ever hire attorneys that are injured due to someone's negligence, but I think most people do hire attorneys, and I think the person says, well, I've been injured, I've been out of work, I've been in pain,
Sure.
I'm incurring medical expense, I'm inconvenienced, my car's in the shop, it's being fixed, I gotta get a rental car. So I think most people say to themselves, well, I didn't put myself in this situation. That person, violated duty of care, they rear-ended me, they hit me ran a red light. So, and then that person says, well, all right, so for my injury, I should be reasonably compensated.
Yeah.
And the law says they're entitled to reasonable compensation.
It's called negligence, right?
Right.
Okay.
Right. So,
But why doesn't somebody just, when it's all over, call the other guy and say, hey, who's your insurance, and just do it yourself? I mean, why would you want to hire an attorney?
well, because people don't know exactly what they're entitled to under the law. So, I mean, the personal injury attorney can inform them of what type of things they can expect to be compensated for: lost wages, pain and suffering, loss of enjoyment of life, mental anguish, permanency, any economic out-of-pocket losses that they incur, medical equipment, medical supplies. So, and many people don't know what the value of their case is worth. And that's the primary reason. They know they've been injured. They know that the law says they can be compensated. What am I entitled to be compensated for if I've been injured? And so that's why you hire an attorney.
I see.
Attorney fills in the blanks. And
brings in the expertise.
Right.
So, I mean, right out of the chute, when somebody comes into your office and said, Mr. Sheldon, I want to talk to you about an accident, I'm sure you go over those things and he'll make the
Right.
decision whether he wants to retain you for those services or not. Okay, so there's always a price tag, David. On the topic of hiring a lawyer, so we hear this a lot. You don't have to pay anything. If you don't get paid, we don't get paid. I think the proper term for that is called a contingency fee. But
Right.
Tell my viewers, and you'll do a better job than I could do, what does that mean? If I were to hire you on a contingency basis, what in layperson's terms?
Basically, a contingency fee is a fee that is contingent upon the plaintiff's attorney recovering some amount of money on behalf of the client. So whether that's by way of a settlement, which is typically what happens in personal injury cases, most cases settle, but it can be by way of settlement, or it could be by way of trial, jury trial, and jury returns a verdict.
Somebody wins, yeah.
And and normally the contingency fee, most personal injury attorneys in the industry charge approximately one third of any gross settlement or gross
I see.
judgment amount.
Okay.
So,
So, albeit, I mean, truth in advertising, and I'm sure you're upfront with all your clients, there's a contingency. Nobody is shelling out money on an hourly basis.
no.
I mean, you're going to be paid if in fact he's paid. And if you go to trial and you would actually lose the trial, then I guess you don't get paid, and neither does
Correct.
a defendant. I imagine while this is going on, David, there's all kinds of negotiations that are going back and forth, discussion back and forth between attorney. So I wrote this down. I'm leading up something here. I know what your answer is going to be. Do most personal injury cases go to trial?
No.
And the answer is a simple no. Okay. All right. So here comes the $64,000 question. If it doesn't go to trial, so how do you get these cases resolved?
Most cases, personal injury cases, are resolved by negotiating with the insurance adjuster. Almost, and I'm speaking about automobile collisions.
Yeah, okay.
I mean, there has to be insurance on the that insures the tortfeasor for the tortfeasor's negligence, the negligent driver's driving.
Okay.
So insurance covers the automobile in question. That person caused the accident, so I would be negotiating with that person's insurance company
I
through one
gotcha.
of their adjusters.
Okay.
Try to settle the case.
So after we exchange information at the scene, wherever that may be, or even the hospital, at some point in time, there's going to be an adjuster assigned to this case. If in fact, let's say I happen to be the injured person and I said, well, the guy calls my house and says, hi, I'm the adjuster from said insurance company, and I say to him, well, I've hired David Sheldon. Does that mean that I don't talk to this guy anymore?
Yeah, in fact, I think for the benefit of everyone that's ever involved in an accident, people have to remember, if you're the party that's been hurt and the other party's responsible, that party's insurance adjuster is not your friend. And the reason is the other side has every incentive to pay the least amount of money to
I see.
me if I'm the plaintiff who's been injured. So they're not on the same side. You know, they're an adversary to you if you're the client who's been injured. The insurance adjuster representing the negligent driver is not your friend.
Okay.
So, and it's not uncommon for them to call within 24 hours, 48 hours of the accident and try and get a statement from the injured party, and the statement could be potentially used against that injured party later on, because the injured party may not know the extent of their injuries and may say, well, my neck hurts, but actually they could develop further pain
Sure,
down the road.
Well, so probably as a point that we might be able to pass on to my viewers, if you're unfortunate enough to be involved in said accident, and I agree with you, I mean, it seems now, in many years of my life, not necessarily being a lawyer, but when insurance issues come up, it always amazes me now how quick that call comes.
Sure.
Years ago, it didn't seem like it, what few cases I've had, but now they call pretty quick. That makes sense, though. They try to get to the guy who was
They
injured.
literally, they come out now with checkbooks.
Yeah.
They show up at the injured person's house and say, Mr. So-and-so, I have a check here for $5,000, and we're going to cover your medical bills, and
Boy, that
for
would-
some people that don't make a lot of money and they got medical bills and maybe they don't even have health insurance, $5,000 probably sounds pretty good to some people. And sign here and you get the money, and here they sign away their
Yeah, that's the
their
point, though.
claim.
If you don't have an attorney, the adjuster comes to your house, talks to you on the phone, we have an offer of money, and the guy who was injured says, yeah, I'll take that $5,000. When he signs on the dotted line, so to speak, he's done, right?
And there's a clause that says you are hereby, by signing below, you are hereby acknowledging full payment and receipt for this claim, and this is the full amount of compensation
So
you will
tomorrow
receive.
morning, the guy gets up, and he has excruciating pain, goes to the doctor, and the doctor says, yeah, this is a direct result of that car accident. I got bad news for you, but you need to go to the hospital. You're going to need an operation. I think you're going to be down for 3 months. You can't go back and...
Can't go back. Now, where insurance companies have to be wary when the adjuster comes out and does that If the adjuster starts talking legalese, things that only an attorney who practices law is trained and has knowledge about, there's a possibility the adjuster is engaging in the unauthorized practice of law by telling somebody this is, reasonable compensation.
I see.
So they have to be careful when adjusters go out and speak to injured people because they can get into hot water.
But having said that, that's their job, though. I mean, they're going to watch that line of practicing law, but they still would like for you to sign that document,
Sure they
give
would.
you some money, because I guess it does two things. Number one, the guy who was driving the other car, the tortfeasor, as you say, he's now done. I mean, there's nothing.
Right.
And also the insurance company, which represents him, they're done too, right?
Right.
Okay. Where if you personally wound up in trial, you wouldn't be facing that adjuster. You would probably be facing an attorney that represents the tortfeasor who
Correct.
works for State Farm or whatever insurance company.
Exactly.
I see. So now we've got lawyer to lawyer. I see. So probably a real good piece of advice, if it happens to any of my viewers, probably best not to make any statements
To the other
To the other
insurance
side.
company. You have a duty on your own policy to cooperate with your own insurance
call your own
company.
insurance guy, and
You have no duty to cooperate with the opposing insurance company.
I see. So all of this, the dynamics of this, which, on its face, I could see where people would come to the conclusion, well, I got in a car accident and somebody's going to give me a bunch of money and that's the way it works. I saw it on television that way. It really doesn't. It actually, I wrote this down. We almost have what I'm going to call litigation versus negotiation. All right, and most personal injury lawyers are pretty good at both of these, I guess.
Sure.
Okay, so before you head for the courtroom, you're going to do your share of negotiation, talk to the insurance adjuster, talk to your client. But actually, while you're doing all this, David, you're sort of building your case as well, aren't you?
Sure, sure.
'cause-
I mean, you want the insurance adjuster on the other side to know that you know everything there is to know about your client's injury, what they've gone through, what you believe the value of the claim is based on your own experience as an attorney, based on jury verdict research, based on seeing how juries in your particular locale have responded to
Similar
personal
thing.
injury cases and what type of verdicts they've rendered. So, and you're impressing upon that adjuster, you know about personal injury, you know how to
Okay.
try a case, and you know what the value of your client's claim is. And that's what you want to convey to the adjuster. And
So, negotiation, all the dialogue that you're having with the adjuster prior to litigation is when you walk through the courtroom door. Litigation, Mr. Sheldon squares off with another lawyer. Negotiation, he's talking on the telephone or meeting with or whatever
Right.
with the adjuster.
Right.
Okay. I think it'd be a fair bet to say that research, my next question is, what factors do insurance companies take into consideration when making settlement offers? And you had the perfect segue. You can do research on how Medina County juries have ruled on similar cases, those cases that got tried.
Right.
You have access to it through the law library and maybe even through some search engine on your personal computer. Is it a fair statement to say, though, the insurance company probably does too?
Sure. Sure. They know what juries are doing.
So would any of them be so brash, either an attorney or an adjuster, when David says, hey, this guy got banged up pretty bad. This could be, I'm thinking 100 term limits. How much insurance has your guy got? Well, he's got 150,000. Well, I think we could be there. Could he come back on you and say, well, Mr. Sheldon, in all due respect, recently in the case of so-and-so, which was decided in Judge Kindler's court 3 weeks ago, it paid. They'll do that.
Sure.
Okay.
Sure. They know they keep a track of what's going on.
And that's fair game.
It's fair game.
Okay. All right, so here's where an attorney wears an interesting hat, because albeit he would like to get as much money as possible for his client, because on a contingency that's how he'll be paid, and being a good lawyer, you're trying to get as much.
Right.
However, if you're client has sort of stars in his eyes as to what this thing's worth, and no, it's not going to pay that, at least in Medina County it's not. Well, I saw on the television some guy out in Los Angeles. Well, yeah, but this is not Los Angeles.
Right.
All right, so now you find yourself in an interesting, which I think we all do, being an attorney is being honest with your client. Sometimes being honest with your client is not what they want to hear.
Exactly.
But you are hired help. And if they want to hear what you want to hear, they might just say, well, see you, Mr. Sheldon. I'm going to go see Mr. Celebrezze. I think you can get more money. They can do that, can't they?
Sure. They're entitled to have whoever they want represent them in a case.
Okay, but I mean, the negotiation versus litigation, I guess the point I'm making as I thought about that, I wrote this question for you because I know you're always in court. You are always litigating. That's the way I vision you. I see you all the time in front
Well,
of
not
me.
always litigating, but
Well,
occasionally.
you go at it more so than most of us. I think that's a fair statement. But as far as the negotiations, not only are you talking to the adjuster, but you're also talking to your client.
Sure.
Where.
You have a duty to convey any offer made by the insurance company to your client, and your client may not always be happy with that offer, and that's when you have to have a sit-down discussion with your client and talk about the pros and cons about that offer and about going to trial.
But if on a contingency, this is all your time, David, and you're a means to the end. If you settle it, you'll get your third. But if you go into that courtroom, I mean, we've both been in there plenty of times. You start bringing experts and just trial preparation materials.
Costs go up.
But the client has to pay for all that.
Yeah, most attorneys in their contingency fee contracts will say, a lot of attorneys will advance the cost of litigation, which would then come off at the
Yeah,
end
sure.
from the verdict or the settlement. So, yeah, if you go to trial, I mean, one thing you have to tell your client is, here's what we're going to spend, or here's what I'm going to spend, and which I'm going to have to recoup from you when the trial's over.
Yeah, and if you lose, you still need to get your money back for paying that expert.
And then most clients probably are not going to be happy to shell out, $5,000 in litigation costs if you lose.
But
So-
if you have a serious injury, you might very well have to bring a doctor in from another state.
Sure.
Who's an expert in this area, and I guess probably the insurance company has got several of those people available to counter your doctor.
Sure, they have, insurance companies have the money, so.
So here we are negotiating with our own client. Well, the offer is this, and your client says, that's not very good, David. I'm not taking that. All right, well, let's talk about what it's going to cost you if we try this.
Right.
Well, when you start adding all those numbers up, I guess that's when you start saying to your client, do whatever you want to do. I mean, I'll try this case for you, but if the verdict comes in at that amount of money, you could either have it right now at that, what they're offering, the $10,000, or you could pay an expert or whatnot, and you might not get much of anything.
Correct.
You might be in a hole.
Might get less than what they offered, and that's happened.
Sometimes in these cases, people do things that hurt themselves, and I don't think they know that they're doing it. I had one of these cases, and it's called contributory negligence. Tell my viewers what that means.
Contributory negligence is negligence on the part of the plaintiff, the injured party. So in Ohio has a 50% or greater comparative negligence law. So that means a plaintiff can be up to 50% negligent and still recover. If the plaintiff's negligence is greater than 50%, they have no recovery. They recover zero.
So in a car accident, how does one contribute to his own demise?
Well, it could be, the issue could be, there may be a liability issue. The liability issue may be who had the right of way at that point in time.
I see.
And if the plaintiff was negligent in his or her actions in contributing to the accident, then you're going to have a comparative negligence instruction go to the jury.
What if I had a wreck, stopped my car, somebody ran into the back of me, I got hurt, but it was determined later on I did not have my seatbelt on? Would that work against me?
Well, under Ohio law, there is what is known as a seatbelt law. And the seatbelt defense is, if you will call it that, seatbelt defense law is if the defense can show that plaintiff's lack of wearing a seatbelt contributed to his or her injuries,
Which it could.
then they could make that an issue at trial and get into evidence the non-use of the seatbelt.
So I
So,
wasn't wearing that thing. If I was wearing it, maybe I didn't bagging around in the cabin of the car so bad.
right.
So I contributed to my own negligence. You're saying then that even if the jury awarded me something, that would lower the award?
Only to the extent that they can show, and they would probably have to bring in an expert. I believe the statute may even require that the defense introduce expert testimony that the non-use by the plaintiff of the seatbelt caused specific injuries for which the plaintiff seeking recovery.
Okay. Well, probably another more egregious example would be that, you have the wreck, you get out of the car and say, the ambulance person says, you need to go to the hospital. I mean, it's obvious. No, I'm fine. You get back in your own car, you start walking, you do something that actually makes your condition worse. But you did it, and the other guy didn't.
Right.
That would be classic contributory negligence.
Right.
Yeah. Okay. Well, here's the situation that, it probably the advantage to hiring a lawyer to look at your whole case when you came in and ask questions like, did you have the seatbelt on? Because I imagine as we move down the road, when depositions start, that attorney from the other side is going to get your client under oath and say, were you or were you not? And if you tell the truth and say you weren't, I'm sure he's going to be taking some notes on that. And the next time you have negotiations, he's going to remind you, Mr. Sheldon, this is where we're at. It's interesting stuff. It really is. Well, David, we're rapidly running out of time here, and I would love to talk to you some more. Would you consider coming back?
Sure, John.
Well,
Nope, I would love to.
Well, we certainly enjoyed having you on a topic that I think is based upon what people say to me in my law office and just my social circles, I think is on a lot of people's minds, and for maybe a number of reasons, but to some degree, sometimes even the downturn in our economy has some effect that people think, well, I had an accident, I can get so much money, but it doesn't always work that way.
Sure.
Well, once again, David, thank you.
Thank you, John. Thank you for having me today.
Comments made by John's guest on Law Talk are solely those of his guest and do not necessarily reflect the views of Celebrezze Zangi Community Legal Education Project. To view this show and others, go to www.czclep.org. In the Wadsworth area, a complete listing of dates and times of this broadcast, tune in to WCTV Channel 15 or log on to wadsworthcity.com and follow the links to WCTV. At CZ we're devoted to the education of today's legal issues. Fueled by the public's keen interest in our legal system and current events, CZ is dedicated to the educational venues aimed at enhancing the understanding by all citizens, regardless of age, education, occupation, or wealth. A function of the Celebrezze Zangi Community Legal Education Project.